In the 1990s, Pepsi aired a wild commercial. A kid flies a Harrier fighter jet to school, lands on the lawn, and it ends with the line, 7 million Pepsi points. There's no disclaimer, no just kidding, nothing like that. But what if someone actually took that seriously? Well, John Leonard did. He raised $700,000, mailed in an order form asking for the jet, and Pepsi responded with, basically, you've got to be kidding. So Leonard sued them. The case is called Leonard versus PepsiCo, and what happened next changed the way companies write ads forever. Welcome to True Court Tales, where courtroom chaos gets the attention it deserves. I talk about the bizarre, the unhinged, sometimes serious, and sometimes even heartwarming courtroom moments. If it happened in court, we're probably talking about it. So let's get to it. By the mid-1990s, the cola wars between Pepsi and Coca-Cola were not just about flavor. They were about lifestyle branding. And Pepsi wanted to target Gen X and younger millennials, positioning itself as the drink of choice for the bold, the rebellious, and the Pepsi generation. Out of this came an ambitious loyalty initiative, the Pepsi Stuff program, launched nationwide in March of 1996. Quote, Pepsi Stuff allowed customers to collect Pepsi Points found on packaging of bottles, cans, and fountain cups, and then trade them in for branded merchandise. A glossy catalog accompanied the campaign, listing awards like t-shirts that were 75 points, sunglasses, 175 points, leather jackets, 1,450 points, mountain bikes, boom boxes, and Pepsi branded gear. It was slick, it was marketable, and it was wildly popular. Young people, already loyal soda drinkers, now had a reason to buy even more. According to Pepsi's internal estimates, over 7 million people participated in the first year. To promote the program, Pepsi released a television commercial that would go down in marketing history, not for its effectiveness, but for the legal storm it actually ignited. So the setting is a stylized suburban morning, and the ad follows a teenage boy outfitted in full Pepsi branded gear. And he walks confidently out of his house wearing Pepsi sunglasses, a Pepsi jacket, and even hauling a Pepsi backpack, all clearly labeled with the Pepsi point values. The music swells and he strides into a high school campus, and then all of a sudden an AV-8B Harrier Jet, which I don't know anything about jets, but the jet screams through the sky and then it lands on the front lawn of the school. So the students are scattering in all different directions and papers are flying, and a teacher gets stripped down to his boxers from the jet's downdraft. The teen then climbs out of the cockpit and he kind of smirks and he delivers the line, "Sure beats the bus." And then the punchline, Harrier fighter, 7 million Pepsi points. And there was no disclaimer. The ad listed the jet the same way it listed the t-shirt. It was crazy and visually stunning and designed to hammer home the message that if you collect enough points, you can get anything, literally anything. At the time, Pepsi executives and advertising agency BBDO reportedly saw the jet as an obvious joke. It was over the top humor for the Gen X crowd, and they would appreciate that. But they overlooked a critical issue. They never included the disclaimer, and the commercial aired millions of times across the US and Canada. To at least one person watching, though, this wasn't a fantasy, it was an offer. So the genius or chaos of the Pepsi Stuff promotion wasn't just in the catalog of rewards. It was in the fine print. And hidden within that fine print was a legal loophole. It was so glaring that it became basically the foundation of one of the most talked about contract cases in modern history. Here's the critical detail. While Pepsi encouraged customers to collect Pepsi points through purchases, the official rules also allowed participants to buy additional points at a rate of 10 cents per point. That was buried in the terms and conditions on the back of the catalog. This clause wasn't wildly advertised, but it was clearly there. And there was another kicker. Only 15 original Pepsi points, so the kind found on actual Pepsi products, were required to submit a valid order. The rest could be purchased directly by check. So we're going to break down the math here real quick, real easy. No math degree required. So 7 million Pepsi Points, which was a number that was shown on the screen for the commercial, minus 15 physical points equals 6,999,985 remaining points that were needed. So that's 6,999,985 multiplied by 10 cents equals 699,998.50. And then you add some for shipping, that would be $700,008.50 total. So that's right. We're talking $700,008.50 total. You could theoretically redeem for a jet worth 32 to 37 million. So depending on the model and military outfit, of course. So this wasn't just clever math, it was contractual math. And to a savvy 21-year-old business student named John Leonard, it didn't seem like an actual joke. It looked like a legally binding offer. So Leonard, based in Seattle and attending Shoreline Community College, and he spotted the ad and he realized that the commercial did not include a disclaimer. And the points were stated very clearly. The price per point was calculable and the rules were public. It was like a legal dare wrapped in a soda campaign. And he was ready to call it. So once Leonard did the math and he realized that the Harrier Jet might actually be obtainable under Pepsi's published rules, he went all in. And this wasn't some kind of YouTube stunt or publicity grab. It was really a calculated legal move on their part. So Leonard began pitching the idea to potential backers like it was a legitimate startup. And his premise was that Pepsi's ad was a contract and the jet was the reward. The redemption loophole made it viable. All they needed was the capital. He approached 5 investors, but one stood out, whose name was Todd Hoffman, a seasoned outdoor gear entrepreneur who Leonard had met while mountaineering in Alaska. So Hoffman wasn't some hedge fund guy. He was a no-nonsense, self-made businessman who appreciated bold ideas. The two shared a trust rooted in their rugged expeditions, and Hoffman decided to fund the venture. With the money secured, roughly $700,000, Leonard meticulously followed Pepsi's redemption process, sticking to every detail in the company's own terms. So what he mailed Pepsi was 15 physical Pepsi points as required to fulfill the real label clause, an order form listing 1 Harrier Jet and 7 million points, a certified check for $700,008.50, and that was covering the rest of the points at 10 cents each, plus postage. And he didn't just send the money. Leonard included a formal cover letter written in business tone, clarifying that the check was not a gag or a misunderstanding. It was a payment for the advertised reward, submitted according to the official rules. In his mind, this was not just a fulfillment request, it was an actual contractual acceptance. Pepsi had made an offer and he was accepting it by performance, just like the textbook unilateral contract. PepsiCo's legal department was not amused. Shortly after receiving Leonard's check and materials, they returned it with a brief rejection. The jet, they claimed, had never actually been a part of the official Pepsi Stuff merchandise catalog, and they argued that the commercial was clearly humorous, a tongue-in-cheek ad that no reasonable person would ever take seriously. They dismissed Leonard's claim outright, stating that the commercial was not a serious offer and therefore not legally binding. But Leonard didn't see it that way, clearly. The ad had aired without disclaimers, used clear numerical language, and featured the jet in the same format as the other merchandise. To him and his legal team, it walked and talked like a contract. The check wasn't a prank, it was a trigger for litigation. And so, Leonard sued. After Pepsi dismissed the Harrier request as a joke, John Leonard didn't back down. In his view, this wasn't just some kind of soda promotion. It was about holding a billion-dollar company accountable for what it advertised. He believed Pepsi had made a public offer and that he accepted it by the book. So Leonard filed a lawsuit in Florida State Court seeking specific performance, which is a legal remedy that, instead of awarding money, asked the court to compel the other party to fulfill their end of the contract. In this case, for them to deliver the jet. So PepsiCo, seeing the public relations storm brewing, went on the offensive. They filed a declaratory judgment suit in New York federal court, asking the court to officially declare that the ad was not a serious contract offer. This was a strategic move. They wanted the case tried in a more favorable jurisdiction. And ultimately, the courts agreed to consolidate both cases in the Southern District of New York under Judge Kimba M. Wood. After reviewing the arguments, Judge Wood granted summary judgment in favor of Pepsi, meaning meaning the case didn't even go to trial. She found that no valid contract existed because no reasonable person would have interpreted the commercial as a serious offer for a military jet. In her decision, she wrote, "The youth featured in the commercial is a highly improbable pilot, one who could barely be trusted with the keys to his parents' car, much less the prized aircraft of the United States Marine Corps." The teenagers comment that flying a Harrier jet to school sure beats the bus, advises an attitude toward the relative difficulty and danger of piloting a fighter plane in a residential area. No school would provide landing space for a student's fighter jet or condone the disruption the jet's use would cause. She characterized the ad as puffery, a legal term for exaggerated or hyperbolic marketing claims that are not meant to be taken literally. Think slogans like "the best coffee in the universe" or "this car will change your life." Pepsi's ad, she said, was in that category, and the Harrier jet was just a visual joke, not a real option. The ruling reinforced the idea that for an advertisement to be a binding offer, it must be clear, definite, and explicit, and must leave nothing open for negotiation. Judge Wood found that Pepsi's commercial was too outlandish to meet that standard. In the year 2000, the Second Circuit Court of Appeals affirmed her ruling, and Leonard lost the case. But he succeeded in exposing just how far advertising can go before it crosses the line into legally enforceable territory. Although John Leonard lost in court, his jet-fueled legal stunt left a lasting impression on advertising, contract law, pop culture, and even the U.S. military. And Pepsi never actually cashed the check that he sent them. They actually just returned it to him. So following the lawsuit, Pepsi re-aired the Harrier Jet commercial, but this time they were prepared. They changed the point requirement from 7 million to 700 million points, an impossibly high number that made the offer basically unattainable under any scenario. They also added a now famous line to the bottom of the screen, "Just kidding." As the media ran with headlines like "College student tries to buy jet from Pepsi," actual questions began to circulate. Could a civilian even own a Harrier jet? The U.S. Department of Defense weighed in, and their position: no. The AV-8B Harrier II was a piece of military hardware capable of vertical takeoff, equipped for combat, and not available to the general public. Even if Pepsi had wanted to honor the deal, they legally couldn't have delivered the jet without major demilitarization. It wasn't just expensive, it was a national security issue. In November of 2022, Netflix released a 4-part docuseries called Pepsi, Where's My Jet? The series revisited the full case and offered a compelling look at Leonard, not as a prankster, but as a thoughtful, strategic young man who saw a legal contradiction and tried to test it. So the docuseries features extensive interviews with John Leonard, Todd Hoffman, who was the investor that actually backed the attempt, and even the lawyer who briefly joined Leonard's legal team before his own legal troubles derailed him. The actual footage of him in this docuseries is while he is actually under house arrest. Some praised the series for blending legal drama with quirky 1990s nostalgia and for showing how marketing law and ambition collided in one of the strangest cases in advertising history. So no, Leonard's jet never really took off, but he'll likely always be the guy who tried to buy a jet with Pepsi Points, all with a straight face. Okay, that's all I've got for you today. This has been True Court Tales. Thank you for watching. Court is adjourned.